Committee on General Laws will come to order.
Professions and Occupations.
Professions and Occupations Subcommittee. If the clerk could open the roll for attendance. Right. Clerk will close the roll. We have a quorum. Thank you. All right, we've got a few bills before us today. I know that we are going to try to utilize a sign-up sheet moving forward. I know not everybody was aware that there was one. I know in the past I said I've sent my staff down, or I've gone down early to sign up, and then found the chair was not using the sign-up sheet, and I was always like, oh man, we flew down here, so I'm going to try to use that. So moving forward, if you do want to try to sign up, I do have Delegate Reeser had signed up, so if you would like to go ahead and present HB 383.
Was on. Good afternoon, Madam Chair, members of the committee. Thank you for the opportunity to present to you House Bill 383 this afternoon. I'm bringing this bill before you to help with an issue that the Virginia Realtors, in conjunction with the Department of Professional and Occupational Regulation and the Real Estate Board, brought to my attention. They have identified the need for more continuing education in the areas of agency contracts and legal updates. And this bill seeks to increase from 1 to 2 hours the continuing education requirements in those areas in conjunction with a reduction in the number of electives by 3 credits to compensate for these new requirements. So it would not change the total number of continuing education hours required. It just refines the focus of mandatory topics and while keeping the total number of credits the same. And this would begin with the next bill renewal cycle. And I'm happy to take any questions. I also have the realtors here to speak to their request.
Are there any questions for the patron before we have public testimony? All right. Is there anyone here to speak in favor of the bill?
Thank you, Madam Chair. We want to thank the delegate for bringing this bill on our behalf. She explained it very well. We're keeping the number of continuing education credits for renewal the same. We're just taking 3 from the elective side and moving them over to the mandatory side. I'm happy to answer any questions, but we're obviously in support of this. Thank you.
All right. Anyone else to speak for the bill? Anyone in opposition to the bill? All right. Any questions from the committee or motion?
Move to report.
Second.
The motion to report the bill, if the clerk could, and it's been seconded, if the clerk could open the roll. It's like I see both. It's registering on the screen. All right, clerk will close the roll, and the bill passes 7-0.
Thank you.
Reports, I should say. All right. All right, next up, Delegate Ware, HB 53.
Thank you, Madam Chair. I have House Bill 53. Ready? Madam Chair, this is a this bill deals with appraisers. I'm going to give you a brief description of it. Then if there are technical questions or specific questions beyond that, I do have several folks who can answer those. Largely what this bill does is give the appraisers a statute of limitations with the certainty of knowing the time frame in which a lawsuit or disciplinary action might be filed. The national standards and Virginia appraiser regulations require the appraiser retain all records available for reproduction for 5 years. This proposed bill for statute of limitations matches that record-keeping rule. If a lawsuit is brought about 6 or more years after the development of the appraisal report and the work files have been purged, the appraiser is left with nothing to defend himself in that circumstance. When an appraisal is developed and submitted to the lender, it goes through review and scrutiny prior to the loan closing, and the appraiser is given the opportunity to amend the report. If an error is detected years later, the responsibility should be borne by the institution that should have caught it at the time the loan was originated. That, in brief, is what we are attempting to do here.
Are there any questions for the patron before we hear public testimony?
Just a quick question, and maybe that it'll come out in public testimony.
Delegate Krizek.
Madam Chair, thank you. So what's the current statute of limitations now? Are you moving it from 2 to 5 years? Is that what this does?
There's a little complication to that, so let me get somebody who knows who can give you a real answer to that question.
Thank you.
Hi, good afternoon. My name is Jean Gannon. I'm a member, past president of the Appraisal Institute here in the Richmond area. The way things are going right now, there's a discovery rule that applies. So the discovery rule is for 2 years. If an appraisal was done more than 5 years ago, if the error was found today, it would be 2 years from today's date. So the discovery rule then is 2 years, and then however much time has passed prior to that. You understand that?
Madam Chair, can I follow up?
Delegate Krizek.
Thank you. So right now, there is no statute of limitations.
No, there is not, no.
So that's what you're saying. So it's just the discovery statute, which applies to discovery in general.
Correct.
Okay.
And we
so-
purge our files every 5 years.
And is 5 years the year, is that, Madam Chair, follow-up question?
Delegate Krizek.
Is 5 years what you really want, or would you prefer 2 years or 3 years, or why 5 years? I understand that that's how long you keep the records.
Yeah, we did the 5 years to match the record-keeping rule, but if you wanted to reduce that, I wouldn't have an argument with that. So.
All right. Are there any other questions? And then we can call testimony. I assume you're here and speaking in favor. And if you have any additional remarks, we'd love to give you and any others that are here to speak for the bill an opportunity to give any additional remarks. So anyone who would like to come up to the podium and speak in favor, please do so at this time. And is there anyone here in opposition to the bill? All right. Are there any other questions from the patron? Delegate Cole?
Madam Chair.
And I see you here, sorry. You are
Thank
on the
you.
board.
I'm new to this process, but I'm just curious if this is dealing with the statute of limitations, does this not need to go before courts? Or maybe that should be a question for council?
Madam Chair, Delegate Cole.
Council?
There are provisions throughout the Code of Virginia on statute of limitations that are outside of Title 8.01. So whether this bill goes to the Courts of Justice Committee or not is up to Madam Chair or the Speaker. I think it is perfectly fine to be in Title 54.1, and it's normal for it to be outside of Title 8.01. So right. I don't know if that answers your question.
Thank you, Madam Chair.
And Delegate, I think it is a great question to consider. I think that it probably is in the correct committee for the scope that it entails. And so I think we can certainly act on it here. Are there any other questions? And Delegate Lefwich, see my board now.
Thank you, Madam Chair. Just a question about paragraph 2. So we're establishing a 5-year statute of limitations, but paragraph 2 indicates that any mishap that occurred prior to July 1, 2024, which is a future date, would be a 2 years limitations period. So you could have a period, you could have, it seems like to me, in my rudimentary, interpretation, that you could have something that occurred today that would have a 2-year period as opposed to a 5-year period. Am I interpreting that incorrectly?
No, I believe you're reading that correctly.
So, follow-up question, Madam Chair.
Delegate Leftwich?
So why would we want to carve out present, why would we want to put a 2-year on some and a 5-year on others? Would the discovery rule apply to those up through the July 1, 24? So in other words, do the old rules apply up till that date and then the new rules apply?
I'm sorry,
after
you're
that?
reading line 24?
No, line 38.
Oh, line 38, okay.
Madam Chair.
Delegate Dreesen.
I just have the same kind of,
Madam Chair, if I might
issue.
ask
Yeah.
your attorney to respond to that question. I'm not sure I have the answer, but maybe. What I was going to ask is if you would be so kind, or if I could ask the attorney to respond. I don't have an obvious quick answer to that.
If council's prepared to answer Delegate Leftwich's question, which may be the same as Delegate Dreesen's question.
it is.
Okay.
Madam Chair, Delegate Leftwich, give me 1 second.
Madam Chair, just
Yes, Delegate Leftwich.
the fact that Delegate Kriesig had the same question I had makes me feel really smart right now.
We'll let the
Madam-
record reflect.
Madam Chair,
Yes, Delegate.
I would have to say it goes the other way. So,
This is a very kind subcommittee today. I'm glad we have
And
this,
one thing I just understand from the petition, as it were, petitioners, they are willing to switch that to 5 years if that would be more acceptable or bring it into alignment.
Delegate Leftwich, did you want?
If we could find, if there's a rational reason for it and council can, explain it to us,
And I may suggest to the patron at this point, if we're talking about moving some numbers, I don't know that we're going to have the understanding of that. If you would like the opportunity to take this bill by for the day, it may.
You're suggesting that might be
I'm
a good-
suggesting that you may want to take it by for the day in that case to give, it sounds like there's some unanswered questions that, and possible amendments that we could attempt to do today, but it might be better suited if you want to take it by for the day. We can just bring
certainly
it back
are.
next week and we can have conversations and. Okay, well, I do think, okay, so they have an answer for this, and then maybe you can make a decision about, I just want to make sure that the members here are going to be prepared to make a decision, and if they're not, you may want to consider taking the bill by for the day, but we'll let council answer, and then
Okay.
we'll see where we are.
So am I taking it by for the moment so the council can answer, or is she going to answer presently, or am I?
So council, I believe, said they were prepared to answer right now,
Okay.
and we'll hear that answer, and then we can see where we are.
Okay.
I just want to give you the courtesy, if you need more time than we have right now, and there's still too many questions, perhaps coming back to this committee next week may be an option, but let's hear what council has to say about the question that the delegates asked.
Very good.
Thank you, Madam Chairman. So originally, the way that this bill was drafted allowed for only 1 year. So for claims brought on or before July 1st, 2021 had to be filed in a proper venue on or before July 1st, 2022, which may have caused some due process violations because you're restricting people to only having 1 year, whereas previously they would have had at least 2. And so by having this new language here and giving them at least 2 years, we're trying to avoid any of those due process violations.
Delegate Kriesig.
Madam Chair, perhaps we just strike the whole section under 2. Is it asking council, is that Was that create any problems? It seems like that's just confuses the whole issue. From line 35 to 41, strike that.
Madam Chairman, Delegate Krizek, I'm not sure whether that would cause any issue or not. We could strike it. I think it just depends on what the current statute of limitation is that applies to these kinds of claims. And my understanding was that there is none as far as, this particular kind of profession, and that but the kind of claim, my understanding was 2 years, but I'm not entirely sure about that, and I'll leave that to the discretion of the committee. Thank you.
We do have DPOR here, and they may be able to speak to that presently if that would be helpful in clarifying.
Okay, that would be great if DPOR could come up to the podium.
Madam Chair, members of the committee, my name is Steve Kirshner. I'm Deputy Director over the licensing division at DPOR. And I believe that the purpose of this subdivision 2 relates to the current 2-year statute of limitations. Since it is currently a discovery rule with the 2 years, it's essentially for those, my guess is it's trying to just let that play out for those that are already in that 2-year discovery window, let them still have this avenue. But the way that I would interpret this or read this, it would be a sort of pick which one if you still fall in that 5-year that the new language proposes. But if you're in that section 2, if your claim would qualify under 2, you still can operate under the current 2-year discovery process. That's the way I would read it.
Yeah, I know. I kind of know what you're trying to do, Delegate. So there's some folks who are possibly in this process under the 2-year discovery rule, statute of limitations rule, but then there's others that have an unlimited statute of limitations because they haven't started discovery yet, and so we're trying to bring them into the 5 years. This is why, actually, what Delegate Cole said earlier. This is kind of a court's type of a bill. Jay and I know about that, and so does the chair being on courts. I don't know. I think maybe it is something we should just, I would recommend, I think, bringing it back next week. That would be my
Take it by for
the day.
So do I hear a motion to pass the bill by for the day?
I so move.
Second.
All right, it's moved and seconded to take the bill by for the day. We'll, that's a voice vote. All those in favor say aye. Aye. Any opposed? All right, bill is by for the day.
Thank you, Madam Chair. Members, I appreciate the time you've taken looking.
We're not trying to kill it. We just want to fix it.
All right, Delegate Wright, HB 57.
Good afternoon, Madam Chair, members of the committee. House Bill 57 clarifies the provision in current law that exempts certain organizations from provisions applicable to restaurants, including churches, fraternal or school organizations, organizations that are exempt from taxation under 501c3, and volunteer fire departments and volunteer emergency medical services agencies applies when such organizations offer food for sale to the public. And what happens in this bill, it includes a participant. And the participant has to meet the same conditions as the person who holds the events. For instance, if a fire department in Lunenburg County had an event in which food was brought to and so forth, then the other fire department in the county that is equally qualified to do so could also participate. And this is on line 18 of the bill, and it just adds after the word hold or participate in. So the person or organization, as long as they hold an event or participate in and are qualified, they're able to do it. But they have to have the qualifications. They can't just come in without having the qualifications and participate in the event.
Thank you, Delegate. Are there any questions? Delegate Creasy, did you?
Yeah.
Oh,
So-
you do have your light. I need.
Sorry, I'm trying to use the electronic.
I know, you're doing a good job
Thank
too,
you.
and sometimes I see it and sometimes I don't.
Delegate, this sounds like a great bill, and you're purely hypothetical situation there, which I'm sure would never happen in Lunenburg, would it? No, it sounds like a real situation that you've run into. So when you say participate, can you tell us exactly what that means? Does it mean so the one fire station or whatever, the firefighters are doing a fundraiser, and then an outdoor event, and then another group is going to have a table there, and they'll be is that what you mean by participating? That they're also there in the event, but they're not the ones in charge of the event, but they want to participate. But right now, are they precluded from participating in the code? Is that the problem that you're trying to fix?
Well, we don't think there's really a problem. This is really just a clarification. Some people will say the person that as long as they're qualified, they can come to the event and bring their merchandise to sell as well. So this is just a clarification to say that if you hold an event or are qualified to hold an event, you can bring your merchandise and sell it at the same place. And this is basically for churches and for volunteer fire departments, EMS, and so forth.
All right, any other questions? If there is anyone here to speak in favor of the bill, we'd love to hear from you at this time.
Good afternoon, Madam Chair and committee members. I am Sandra Tanner with the South Hill Chamber of Commerce. I want to thank Delegate Wright for patroning this and bringing it forward and for your consideration. The South Hill Chamber of Commerce supports this bill for nonprofits who currently hold bake sales as fundraisers in the current legislation to have it so that they are allowed to hold them at community events and festivals, such as our Holiday Bazaar. So currently, the Palmer Springs Fire Department they can have a bake sale, but they cannot be at our Holiday Bazaar. And our bake sale is a block away. So we just want to make it so that they can participate in both.
All right. Is there anyone here to speak in opposition to the bill? All right. Is there a motion?
So moved.
Second.
She was the one.
Move to report.
Second.
So moved and seconded to report the bill. All those in favor, please indicate so on the electronic board. All right, the clerk will close the roll. The bill reports 8-0. Thank you, Delegate.
Thank you very much.
Okay, Delegate Wiley, HB 287.
Good afternoon, Madam Chair, members of the committee. I have an amendment that's in front of you. I need adopted, please.
All right, do we hear a motion to adopt the amendment?
So moved.
Is there a second? It's been moved and seconded to adopt the amendment. All those in favor say aye. Aye. Any opposed? All right, the amendment is before us. Delegate?
Thank you, Madam Chair. This bill seeks to modernize the definition of geology and practice of geology in the Code of Virginia. Currently, since geology, geologist, and the practice of geology was first included in the Code of Virginia in 1988, there have been no updates made to any of these definitions or their applications. So for the past 36 years, provisions regarding geology have been moved around the code, moved in and out of the oversight from various regulatory bodies and governing boards, and seen other similarly situated professions embrace much-needed updates. But there has never truly been an accurate description of this profession or its practices in the code. In recent years, there have been various attempts to deregulate the industry as well as to change or even abolish the governing boards for the profession. In large part, this is due to a misunderstanding of what exactly the practice of geology entails. All too often, there is a misconception that the practice of geology is little more than people looking at rocks, but that could be further from the truth. So the solution, we seek to modernize the definition of the practice of geology so that it more accurately captures the important, widely varied work that geologists do. Virginia geologists are critical to the health, safety, and welfare of both the public and the environment across the Commonwealth. Geologists work in a wide variety of industries, perhaps most predominantly in infrastructure, mineral resources, energy and water, construction, and more. They work closely with professional engineers and architects, local government, and state government entities, including state agencies like VDOT and DEQ. Some of the examples of the services they do is water supply studies and monitoring public-private water supplies, construction inspections and safety monitoring. Some of the projects they've done in the past, I-64 sinkhole address near Waynesboro, Route 123 bridge, inspections and analysis of new foundations over the Occoquan River, and brownfields assessment cleanup in Pulaski, Virginia, to name a few, but there are many. So with that being said, Madam Chair, there are countless other things that the geologists do that we'd like to get encompassed in this bill. Please note there's no fiscal impact. Senator Rouse is carrying the companion bill in the Senate, and I appreciate the passage of this bill. And I do have some folks here to speak to it. Please.
Okay, so before we go to that, we have a couple of questions from members. Delegate Lefwich.
Delegate Wiley, could you explain to me the difference between an igneous, metamorphic, and sedimentary rock?
I was, Madam Chair, I was asked to not make any jokes about rocks today, so I'm going to defer to the experts.
Okay. Delegate Krizek.
I don't want to wait too long, Madam Chair, for the answer to that, but I know in geology things move slowly. But I do want to say I think this bill rocks.
See, there's one. Madam Chair.
Thank you, Delegate Krizek. Delegate Cole, what do you have for us?
Thank you, Madam Chair. I'm not as funny, so lo siento. I'm just taking a look at line 20, and I would ask, Madam Chair, if the gentleman would be able to explain why we're moving public from line 20. What's the difference between public practice and practice?
If I may defer to the experts on this. Thanks.
Thank you, Madam Chair. Delegate Cole. Chris McDonald from Williams Mullen on behalf of the Association of Environmental and Engineering Geologists. The choice change of that language there was that we felt that by just having public in there, it was too limiting to actually capture the wide array of work that the geologists do, both for the public sector and the private sector. So, simple fix.
Thank you, Madam Chair.
Thank you, Delegate. All right, so if there's no other questions, if you want to speak in favor or anyone else would like to speak in favor, now would be the appropriate time.
Sure. Thank you, Madam Chair. Once again, Chris McDonald with Williams Mullen on behalf of the Association of Environmental and Engineering Geologists, the leading international trade association for practicing geologists. I think Delegate Wiley did a great job explaining the bill, so I won't belabor it. We really appreciate his work on this, and I'll save the rest of my remarks actually for practicing geologists who traveled down to be with us today. But we really greatly appreciate this and hope you'll support the bill.
Hopefully we'll have an answer for Delegate Leff, which is an important question.
Thank you, Madam Chair. I'm Drew Thomas, and I'm a lifelong resident of the Commonwealth of Virginia. I've been a Virginia Certified Professional Geologist since 1997, and I'm currently a Principal Engineering Geologist with Engineering Consulting Services, and I split time between the Chantilly and Winchester, Virginia offices. I've been an active member of the Association of Environmental and Engineering Geologists since 1988. On behalf of my firm and the members of AEG, we're pleased to support House Bill 287. This bill modernizes the definitions related to the geology profession by more clearly enumerating the many aspects of the profession and properly relating our profession to public protection. I'd like to thank Delegate Wiley for his leadership and support on the bill and respectfully request that the committee vote in favor of House Bill 287.
Thank you for being here today. Is there anyone here in opposition to this bill? Do we have a motion?
Move to report, Madam Chair, with amendments.
Second. All right, it's been moved and seconded to report this bill with amendments. Clerk will open the roll. Clerk will close the roll, and the bill reports with amendments 8-0. Thank you, Delegate.
Thank you, Madam Chair. Have a great day.
Thank you, you too. All right, Delegate Owen, HB 350.
Madam Chair, members of the committee, thanks for having me today. We do have a substitute with amendments. Okay.
So, Council, we have substitute or amendments?
Madam Chair, line amendments, and they are.
If you could report those, please.
Available online, and yes, I can report those. It just, at the beginning of line 23 of the bill, unstrike the stricken language that says 9, which is currently stricken, unstrike that. So put it back to 9. And then after the stricken word engineers, insert the words at least.
All right. Is there a motion to adopt the amendment?
So moved.
Second? All right, it's been moved and seconded to adopt the amendment. All those in favor say aye. Aye. Any opposed? All right, the amendments are before us. Delegate, you can present the bill.
Thank you, Madam Chair, members of the committee. Currently, the Board of Architects and Engineers is having a problem getting their quorums. And it's not that they don't have a quantity issue. And initially, this said 6, and we brought it back to 9 because we don't want to reduce the quantity. It's the mix of the quorum. So when they have the informal finding hearings, they need their current members because they are the experts, and they use those current board members in those hearings. And so they also become the presiding officers in those hearings. And once they have been involved in those hearings, they're not able to sit on the board. So sometimes they don't have enough. They don't have 2 engineers and 2 architects. So they want to do this because they are not able to adjudicate the cases that come before them within the statute time. So we'd like to change, the board is asked to do this, and we'd like to change the mix of the quorum.
Thank you, Delegate. Are there any questions for the patron? Delegate Cole?
Thank you, Madam Chair. Would the gentleman be able to explain when you say the mix of the quorum? Because as we're looking at...
So currently the quorum requires 2 engineers, 2 architects, 2 land surveyors, 1 landscape architect, 1 interior designer, and 1 non-legislative citizen member. So what that first line is going to change to is 9 board members consisting of at least 1 engineer, 1 architect, 1 land surveyor. The rest stays the same. So you're reducing the number of required engineers from 2 to 1, architects from 2 to 1, and land surveyors. That is the major change in the bill. But the total number of the quorum will stay the same.
Delegate Krizek?
Can I check with council? I think there may be something that needs to be fixed here. So lines 23 now, with as amended and as the delegate just presented, we're cutting down an engineer and an architect. And so now we're down to 7.
But it says at least.
Where's the words at least? I don't see that.
Madam Chair, Delegate Krizek, it's in the line amendment that's online.
The amendment.
We're adding
Oh,
the
you
word.
did put in, okay, I don't have the thing.
So now that line will read 9 board members consisting of at least 1 engineer, 1 architect, 1 land surveyor, 1 landscape architect, 1 interior designer, and 1 non-legislative citizen member shall constitute a quorum.
Thank you. Follow-up question?
Delegate?
So where will these other 2 people come from that are on the, that would make up that quorum?
Madam Chairman, Delegate Krizek. So there's still going to be the other members, but at least you want that mix. So you may have 3 architects and only 1 engineer, or possibly 3 engineers, 1 architect. So it's the mix there. So it's still, you still have to have a total of 9, but instead of having 2 required now engineers, 2 required architects, it reduces that to 1 of each of those.
I got
minimum.
You. All right, thank you, Madam Chair. Thank you, Delegate.
Are there any other questions from the committee? Is there anyone here to speak in favor? Oh, I'm sorry, Delegate McClure.
Thank you, Madam Chair. Just a quick question for the delegate on line 32. Is that still included in the amendment? Just wanted to get some reasoning for why that part was stricken.
I've got people here from D4 that can address that portion of it. But yes, that is still part of the bill. Thank you for pointing that out.
All right, and at this time, if we would like to go ahead and take testimony for, or I guess if you answer that specific question, and then we'll go ahead and take testimony for and against the bill. But
All right, thank you, Madam Chair. Members of the committee, again, my name is Steve Kirshner with DPOR. The purpose of the line 32 amendment to strike the provision that the licenses be signed by 4 board members is that there's really no administrative need for that requirement. We're having board members sign thousands of licenses every year, and it's not really doing anything. It doesn't add any protection to the public. It doesn't provide us any fraud prevention, and so it's removing a burden for our board members that's not providing any benefit. And DPOR does support this bill. These are changes that were requested by the board itself. Thank you.
do you have a follow-up question?
Yeah, Madam Chair, follow-up.
Yeah, follow-up.
Follow-up question for you. Do you know the initial reasoning why they put that in for the 4 signatures?
Madam Chair, Delegate, I actually do not know the original reason. It's been in the code for quite a while, but I was not here when that was made, and I don't know the reasoning.
Delegate Krasik.
So right now in the code, no one has to sign anything. Is that when I read that? So now there won't be any license signed by anyone?
Madam Chair, Delegate, that is correct. There would not be a statutory requirement for the license to be signed if this were put into effect. That would be the same as the other professions under DPOR. Currently, the licenses that are printed have the digital signature of the DPOR director, and so that would continue. In this particular case for this board, the signature is actually going on to what we would call the wall certification. It's sort of the big license certificate that you might see framed in someone's office. So that would no longer be a statutory requirement that the board members sign, that 4 board members sign that document.
Follow-up question? Does that answer your question?
Well, it kind of. So in DPOR, following up, Madam Chair, so DPOR now has there's no other licensing that you do that has signatures of the commissioners or of the group that's responsible. Is that correct?
And, Madam Chair, Delegate, there is actually one other board. It is the Board for Branch Pilots that sign their licenses. This is a relatively small board. There's under 40 members, and they take great pride in signing each one of those. Yeah.
All right, there's no further questions at this time. Anyone who's here to speak for the bill, please go ahead and approach the podium.
Thank you, Madam Chair. Thank you, committee, and thank you to Patron Owen for putting this bill forward. My name is Christina Preisner. I'm with the American Council of Engineering Companies in Virginia. I am here to support this bill. We've read through the amendments, and we are here to support the fix of this issue. So thank you for your time of looking through this.
Madam Chair, Committee, I'm Paul Battaglia. I'm the Executive Vice President and also a member of AIA Virginia, which represents the architects, and I'm also, as a licensed architect, a regulant of Appel Sidla. So we also stand in support of this bill. This otherwise impedes the very good progress of the board, and so we appreciate DPOR having brought it forward, Delegate Owen for having sponsored it. We do recommend that you accept it. I think it rectifies the problem and respects the composite nature of our board. Thank you.
Chair and members, I'm Kishore Thota, the director of DPOR. We also oversee the geologists, and I just want to say this bill rocks as well and would be a big help to the agency. Thank you.
All right, is there anyone here to speak in opposition to the bill? Delegate Fowler, did you have a question? Okay. I was trying to read your cues. I had heard some feedback from members that think we have probably a better understanding now than we did, but I know that there had been some questions, and I know I'd been asked by members if we'd have the opportunity to maybe have some more meetings just to make sure we got it and we understood. I think there may have been some ongoing questions, and I can't speak for my colleagues, but if reducing kind of the proportionality would favor one industry over another, or would kind of leave somebody out of a conversation, a subject matter expert might not be in the room, yet a decision that might affect that field might be taking place because a quorum might exist. I think those are some questions that I was told by my colleagues may still be outstanding. So for that reason, I had suggested that we hear testimony today. We have the opportunity to understand where we might fill in some of those gaps, but to give those members the courtesy and the patron the courtesy to get those questions answered, that we could take the bill by for the day, and then come back for a vote at the next meeting. And that would give the patron and those members the opportunity to see if those questions could be answered. And we'll be able to come back and take action next
Madam
week.
Chair, if I may, we've got the experts here. If there are questions out, I'd love to get them out of the way.
I understand that, Delegate, but I had been asked by my colleagues for that courtesy to just have maybe some of that sit down and understand. So I think that's the action we'll take today, and we will see you back next week when we meet again. So a motion to go by for the day would be in order.
So moved. I move that we go by for the day.
All right, it's been moved and seconded that we go by for the day. All those in favor say aye. Aye. Any opposed? All right, the bill is by for the day, and we'll see you next week.
Madam Chair, members, thank you so much for your time.
And Delegate Sullivan.
Thank you, Madam Chair. How's that for timing?
Perfect timing.
Madam Chair, members of the committee, HB 120 addresses a situation that a constituent brought to my attention, and which I understand is I don't know how broad the problem is, but her situation was not unique. Hence, I brought 120. It has to do with the nursing profession. This woman is a very experienced nurse, long career in nursing. She told me the story about receiving receiving her notice to renew her license. She received it late. It got sent to the wrong address. She had moved. I mean, there was a whole story. But the bottom line is, through certainly not her, nothing she had done wrong, but just because of circumstance, they did not receive her check, and so her license was suspended. It ultimately all got worked out. And again, I want to emphasize this has to do with a woman, and this would apply to all people who have some sort of inadvertent, purely financial, haven't paid your annual fee. But what happened to her was this got reflected on the website that employers go to check on a person's status, their licensure status, as a disciplinary action, as if she had committed some professionally negligent action. And she found that therefore made it hard for her to get even an interview, let alone a job. I'm not. The bill doesn't. I'm not suggesting any fault on anyone's part within the boards that oversee this. I just think that the language of the statute, which they are simply trying to comply with, doesn't make clear that the distinction between a problem with someone's licensure that was purely a bad check circumstance and one which would reflect on a person's professional capabilities. And so what 120 does is simply make very clear that in a situation in which there is a failure to pay, that not be reported as a suspension, or that it only be reported as a suspension and not considered or described on any official documents as any sort of disciplinary action by the board. And that's my very simple bill.
Thank you, Delegate Sullivan. Delegate Leftwich has a question.
So I think actually that's exactly what the Bar Association does, doesn't it? It just says suspended for non-payment. It doesn't reflect a disciplinary action necessarily. Just like if you read the professional notices, it just simply says suspended for non-payment of fees.
Yeah.
So what's good for attorneys should be good for other folks.
Yeah, there are confidentiality things associated with those things. But I think, Madam Chair, I think the delegate's exactly right. That's certainly my experience in my profession. And I just want to describe for the committee the sort of pain in this woman's eyes. She's a nurse, desperately wanted to work, and was just having trouble getting anyone to even talk to her because the impression given. Now, I think they could drill down, and you can call and find out. The details were there in the system, right. But the impression given to an employer, looking quickly through someone's background, is that this person had some sort of professional issue, right. And I'm simply trying to remedy that.
All right. If there's no other questions, is there anyone here to speak in favor of the bill?
Paul Battaglia, AIA Virginia, also regulant of this same board. So as long as we're here and we're offered the opportunity to comment, we appreciate the sympathy that goes into this bill. We understand the distinction from elsewhere, and we have no objection to this bill. Thank you.
All right. Anyone here in opposition? Do we have a motion?
Second.
It's been moved and seconded to report the bill. All those in favor, please indicate on the electronic voting board. Clerk will close the roll, and the bill reports 8-0. Thank you, Delegate.
Thank you, Madam Chair and members of the committee.
I believe that is all of the business before the subcommittee. Do we have a motion to adjourn? All right, moved and seconded. All those in favor say aye. Aye. Committee is adjourned. Thank you.